colleagues. Well, this presentation, the title, we are going to share it with Mr. Chilongo. So I'll do part of it and he'll do the remaining. I know after lunch all of us want to rest and relax, so I'll do my best. How many minutes do I have?
I'll give you 30 minutes, madam, maximum.
Thank you very much. Okay, I was once also just like you at Africa University in the 5th cohort. Yes, so in the 5th, yes, 5th cohort. And most of the presenters, they were also my lecturers. And I thank Aripo that having been given this job, so I'm plowing back towards what I learned to put it within the African region for the benefit of the member states. Okay, the topic, as you see, it's benefiting from copyright and using copyright of others. And my outline is as follows, that I'll go through the IP, the copyright and related rights, ownership, limitation of monopoly, digital use, and how to benefit from copyright, using copyright of others. And I'll conclude. Most of the things have been said, most of the things you have learned, and this makes my work easy because we are all sailing in the same boat. And I expect that we won't leave anyone on the way. Intellectual property, as you all know, that it's on creation of a human mind, and that it's on the industrial property part, and there's the copyright part. And these things, they have different types of rights which go with IP. And these rights, we find that we have several of them. That is the intellectual property tree. And we have patent, copyright, utility model, industrial design, geographical indication, integrated circuits, trade secrets, we have traditional knowledge, we have the trademark, we also have plant varieties. So with all these being the rights that one can have depending on the IP that they have, and they should be utilized within our countries, and we have to pass that knowledge to the respective group of people so that they too can utilize these IP rights for the benefit of themselves and even of the country and Africa at large. We find that copyright and related rights, the copyright is a legal right that gives exclusive rights to the creator on an original literary and artistic work. And these works, they have to be in a tangible form, fixed in a tangible form, and it all goes back to the laws of your country. What does your law say insofar as copyright is concerned? Is there a need for fixation? Is there a need of originality? Is there a need of having it to be in a specific form? When we go to the related rights, and some of the laws, they call them neighboring rights, we find that these rights are the underlying rights to the copyright work. So they are rights for the performers' rights, producers, and also for the broadcasters. At times they are also called entrepreneurship rights because they help that copyright work to be into the public in different kinds of mode. But this copyright, we see that it's a creation of human mind. And that is the creation that we have. You create something, you become creativity. You become creative for the creativity work that you come up with. And some of the laws, they have the protection as in 50 years, others 70 years, and in others it's 90 years. So 50 years from plus, that is the copyright is from the death of the author, plus either 50 years, 70, or 90 years, depending on your legislation. And it grants exclusive rights, and the exclusive rights, some of them are on those all arrows. Those are some of the exclusive rights that you have: the distribution right, adaptation, assigning, you have public performance, you have the translation right, you also have the broadcasting, you have the licensing. So all those rights are granted exclusively to the creator. And we see that there is also the moral right that a creator does have. Each kind of work, when one comes up with, has different intentions, on that particular have different intentions on what that particular work is to be used for. Therefore, the moral right on the personality that he has a right to be recognized as the author of that particular work, and the right to integrity, that it should not be used against the means or ways that he had actually intended it to be used. And some of the literary and artistic works, we find that these are examples. This particular artwork, the person has used a brand. We see the women craft. So at least they have a knowledge on that there is a need to have a specific label, so that when we sell our items, people recognize they're from which source. And those are some of the copyright things that we have in terms of film, cassettes, paintings, photographs. Artistic work for the visual arts. And in this case, we are having challenges with visual arts, because in most of our legislations, we don't have the resale right, which is to provide for a subsequent sale of any artistic work when it's being sold in auctions, so that it can benefit the one who has actually authored that particular work. So it's for our duty, in terms of when we are amending our copyright and neighboring rights laws, to incorporate the resale right, which will benefit the right holders for artistic works, in terms of the ones for visual arts, fine arts, and also the sculptures and the like. So the general rule is that the creator or the author is the first owner of that particular work, but this is subject to change. And the change now comes from the exceptions that we have, depending on what made this person create that work. If it was during the employment period, then most of the laws, they presume that the work is owned by the employer, unless a contract to the contrary, or if it's commissioned works, or if it's works that are owned by states. So all these things, they have to be taken into consideration to know the proper right holder. And as we heard from other speakers, that they were facing challenges in who is to be paid. Who is to be paid on that particular work, because a copyrighted work has come up and it has involved several people during all to come up with a complete work. So who is the proper party to be paid? It all goes back to a proper documentation on the contracts, as from the grassroots, the composer of the work, and throughout to all other parties who are involved. But the problem that we have is that most of the artists, they do things in a friendly basis, and this, at the end of the day, it costs them. And they end up saying that copyright, what should we do? Our copyright has been stolen. Yet, they didn't follow the proper procedures. So limitation to copyright, it being an automatic right, it being a right that grants exclusivity on all the bundles of rights that we had looked at. We look at limitation on the exceptions and limitations that most of the laws have, and we have for the purpose of research. We also have criticism and reviews, and also in news reporting, that these are just some of the things which bring about exceptions and limitations that you are not required to actually go and ask for permission from the copyright owner. Even if you're quoting something, provided you bring up the proper source on where you quoted that particular article. When we look at the digital use, we find that it has brought a lot of issues and questions on the digital content, and that whether copyright is still relevant. And we find that the digital content is still relevant, as it is also copyrighted work. And in the international arena, we have various kinds of treaties and conventions, and some of them are listed, which took into account to incorporate digital environment issues. So the technology, we have the internet, which has brought about the live streaming, the webcasting, we have the rebroadcasting, file sharing, downloads, and social media. Within a click, everything goes to everyone and throughout the whole world, just within seconds. So this has brought a lot of challenges and issues to be looked at in the digital environment, because the reproduction is very fast. Reproduction is fast. There is no need of the right holder to grant permission now anymore. Because if I give it to somebody, the right holder has no control over that work anymore, because it just passes on and on and on. So it has brought a lot of things that has made us to think. And we have the file sharing peer-to-peer, the videos on demand, and also the collective administration of these rights. How can we collectively manage the digital rights? We find our brother from Uganda, they say they had opened up a music store. So what proper means should they have done maybe to manage those rights of those people? And due to the internet technology, the borderless nature of this internet, and if at all we're going to use technological protection measure, which ones are the best to fit specific situations? There are others, like if you take somebody's text and you want to copy it, it will just show that you have copied, that this one, the author was so and so, it was published, or the publisher is so and so. So it will make it's something that no matter what you do, it will just be seen that you have copied it from somebody else. But all these are technological issues which are a challenge to most of us on how best and how should we do it. Others are encrypting, but all these things, while you are thinking of protecting, others are thinking of bypassing your protection. So everyone is working day and night to see what they should do. And we find that the internet service providers play a major role in terms of disseminating these works. And when we look at the Digital Millennium Act, we find that it has the takedown, cease and desist, and also we have the other things of safe harbors. So all this is a challenge which has been brought in terms of copyright is concerned. How best can it be done? So when we look at how do you benefit from copyright, we find that the best way is on the management. How can you manage your copyright? That is the first thing. because there is the traditional way and the digital use. Traditionally, we never used to have the digital things. It wasn't, the internet was not that too advanced. So people had control over their works, and they knew whether they're going to give the specific right, that they have control over it. So management is very important to plan on how you're going to exploit your work. But all this also depends on the owner of the copyright. Some people decide, I'll just put it in my cupboard and that is it. Even though it's a creative work, because there's no need for registration, there's no need of I taking it anywhere, provided I have a creative work, that is it. So I'll manage it in my drawers. But others who need to take it to the markets now, they look at several things on commercialization, on whether they're going to license. And if they're going to license, will it be exclusive or will it be non-exclusive? And will the payment be a one-off settlement or will it be a recurring payment? So this exclusivity and all that, you can divide it on having terms and conditions, which is best for them to be in written form. And those terms and conditions, they can now look at the market. What type of market do you want the one who you are entering into a contract to take, the publisher, to take your work to the market? What particular contract do you want him to have? Is it only in Zimbabwe? Is it for the Africa? Is it for specific countries in Africa? So it's upon the right holder, the owner of that copyrighted work, to choose. And also the time, the duration of that particular contract, and the language, if at all there is need to be translation of that work, or if there is need to, compile things, and so many things that will make your work go to the market. That will make your work, go to the market. And for example, when you assign the work, are you assigning everything or it's just part of the work? And also, if you're giving it to the publisher, are you completely giving out all your rights, or you still maintain some work? And if it's a book, you also have to look at who you're giving it to, and the radio stations and TV, everyone that you want to use as commercializing the work. You have to be very careful. It all goes back to the contract. So our duty as MIP students, when we go back, we have to sensitize our people on the importance of written contracts, not oral contracts. Written contracts are very important, and the essential elements of that contract pertaining to their copyrighted work. And this will enable them exploit their work, commercialize it, and they find benefits in having that work. And it will actually uplift them, and they'll come up with many more works, and this will contribute more to the economy and also to the country's economy. At the moment, it's only 3 Aripo countries, that is Kenya, Malawi, and Tanzania, who have had the study for national, the contribution of copyright-based industries or creative industries to the national economy. And in all these cases, we find that they are contributing quite a lot, more than what people thought that the creative industries are contributing. You find that most of them, as from 4 to 5%, are contributing to the GDP and also to employment. So all these things, it's for you to at least pass it on to the people who are within our offices, and also to all those who are concerned in coming up with policies, so that they can understand the importance of copyright to the people and to the culture of the country, so that we can actually uplift it and grow positively. So So also another way that one can benefit from the copyright is through merchandising. And in merchandising, we find that it can be used, the artistic work can be used in different things like t-shirts, mugs. You can just put a label and it sells, or a photograph. But you should also be very careful in order to get clearance on the pictures that you put, if at all it has something on, or a personality, a person, so that you do not interfere with the privacy rights while you're using all these things. So we have to be extra careful while we want to use this. And this can really help, because we find that most of the artists, they have beautiful things which can also be used in other kinds of ways to exploit them and to give them an extra income, the equitable remuneration that they can have pertaining to their work. Coming up with posters, with billboards, with all these kinds of things. It's a matter of them to be told, your work, it's not only just a portrait, it's not just a picture. You can exploit it by using it in another way. Your sculpture, you can make something out of it. So it is for us to spread the gospel on it. And also another way we find that how you can benefit, as alluded earlier, that some people, they just prefer maybe staying with the work, and others, they prefer giving it for free. So whatever way you have decided to use, for example, the open access, people expect, because it's public funds, so the researches that have been done to be available publicly for the benefit of the public. And this copyleft thing that you can edit, you comment, and then you forward to other people. So all these things, what do you want to do with your work? Do you want it copyright? Do you want it copyleft? It's for you to decide. So using copyright of others, the basic thing is the permission, authorization from whoever is the right holder. We need authorization to exploit other people's work. Without it, it means that they can sue you and you can pay a ransom, or you have penalty. And in looking at some of the examples, in music, for example, the rights that are there that can be exploited, the public performance, broadcasting, reproduction, synchronization, communication to the public. So whatever you want to do with the music, if it's putting it on the phone as a ringback tone, you need to have the right for that, because you'll be actually changing some of the features of that music to fit your actual work that you want to do. If you want it to be broadcasted, so all these things, you cannot just go on to do these things without permission, and that is why we have collective management organizations which at least take charge of some of the rights that the right holders have assigned to them. And they help to minimize a person from, all artists, from knocking at each and every broadcaster that they want to be paid. So through the collective management system, at least it has made it easier to curb that particular problem. And in the countries, some of the countries, they have the collective management systems for the different rights. Others, it's only one for all the rights. So it depends on your legislation on what it provides. Likewise, on photographs, we have the reproduction, communication to the public, adaptation, personality and privacy rights for the well-known persons. Painting, likewise, on the usage, because the minute that you take one to do it, to put it in another form, like a painting, and then you put it now in a print, so it means you are actually reproducing it into another form, so you have to get clearance on that particular aspect. And for books, there are different kind of things that are involved. We have the text, the images that are there, and all kinds of artwork. So we have also to be careful when we are reproducing these things. That is why in most of the countries we have the reproduction rights societies, the RROs, who are actually collecting royalties on behalf of the ones who have this, the publishers and the authors for the reproduction rights. Public domain works. For you to exploit these public domain works when a work has actually expired in terms of it has been protected throughout the life of the author and plus 50 years or 70 years or 90 years depending on the legislation. So it enters into public domain, and whatever work is in public domain, one can use it to come up with a creative work, something that is new in terms of how you arrange that particular work to fit your situation at that time. So in knowing what kinds of work are in public domain, you can consult several offices, as the Copyright Office or the Collective Management Organization, or even the Public Register, that maybe you know a certain author died in some years back. So you want to check if these years have already expired so that you can use the work to come up with a new work. But you will only get copyright on the portion that is new, that is creative. Because if you mix whatever this other author had and what you'll now come up with, then it means copyright will only be on this new aspect that you've brought, but not on everything that is there. My conclusion: copyright, being creation of human mind, has to be valued. Right holders should see that their works are business products, hence need to be commercialized in the best way possible to provide access, limit piracy, and be equitably remunerated. Written contracts are very important. It needs concerted efforts. We have to collaborate, whether you are in the right holders institution, in the government side, in the private sector, and the public. All of us need to collaborate. This is not a one-man's fight. It's for all of us, so that we can move forward in terms of copyright and related rights is concerned. Thank you very much.